welcome everyone to today's session. Just a few housekeeping notes as we get started. I discovered as I was going through the slide presentation that in the upper right-hand corner, we do have some page numbers referencing the materials. And I also noted that many of those are incorrect. So I would ask that you white those out, take a magic marker and scratch them out, whatever you'd like to do. And I will be referencing specific pages in the materials as we continue this afternoon. Also, at the conclusion of your materials on pages 36 and 37, I have some of the case study examples spelled out step by step that we will be discussing during the other portion of the presentation. So feel free to either pull those out and refer to them during the presentation or have them for reference once we conclude. So to set our agenda for today, the number one issue I see when we're examining debit card questions are we have institutions that know what Reg E requires. They also know that what Reg E requires is in conflict with what Visa requires, and they just don't know which set of rules they need to follow. So we're going to be looking extensively at that conflict today. Also, I know we've had some questions on business debit cards. They're not covered by Reg E, so how does Visa apply to them? Another big one is zero liability. What does it cover? What does it not cover? So we will take a look at that as well. We'll look at the chargeback process step by step that we can use to try to recover funds for both our customer and for our institutions. And again, we will have some specific case studies to look over. And then we will conclude today with a brief look at the compliance process and some of the scenarios that we can use for that, again, to try to recover funds for the banks. As Sam indicated, we will take a break in the middle to give you all a chance to digest what we're covering in the first half, and we will go from there. So to set the framework, we're going to discuss what are some of our responsibilities as a Visa issuer. And the first is that we must attempt to honor all transactions. You get your daily file with your settlement, and it's got all of the transactions done on your cards. And of course, there always seem to be a few that reject for one reason or another, whether the account's overdrawn, the card has been previously closed or expired, whatever the situation. And unfortunately, unlike an ACH transaction, we don't get to just simply send these back because we feel like it. If the account's overdrawn, these are forced pay items. We have to overdraw it more. If the account's closed, we're looking to see if the cardholder has a different account to try to post the transaction. Now, later in the presentation, we will get to talk about what happens if we can't post the transaction. Are we stuck with these charges? Where do we go? We're going to discuss that as well. Now, when I first started doing debit card processing, I always thought, hey, if Reg E doesn't cover it, show them the door. It's between them and the merchant. We are actually contractually obligated by Visa to assist our customers. And what that means is if they present a situation where the chargeback process can help them, even if Reg E doesn't apply, we're going to be obligated to take the chargeback steps, work with our customer, work with the merchant, and we're going to discuss those in detail as well. And lastly, a concept known as unjust enrichment. And what an unjust enrichment means is no one's allowed to profit by this process. As an example, you have a cardholder that files a claim, and so you charge it back, you get the money, you provisionally credit them, and then you happen to notice that the merchant also issued a refund. Well, the cardholder doesn't get to profit by the chargeback process, so of course you're going to revoke one of those duplicate credits because the merchant's going to get their money back. Similarly with Reg E, in some cases we're going to be able to say, hey, Reg E says our customer's liable for $50 or $500 or whatever the dollar amount might be. Well, if we successfully file a chargeback and recover 100% of the cardholder's dispute, just because Reg E says you can hold them liable for $50 doesn't mean that you get to pocket the difference. So the bank is not allowed to profit by this process. If you recover 100% of the dispute, you give 100% of the funds to your customer. You don't get to offset that against prior losses. So we're going to take a look at coverage for Reg E and Visa, and we're going to compare several steps in the investigation process. Now we're on page 4 of your materials, and we have a list there in italics of 7 errors that Reg E is defined. Now for your cardholder's dispute to be covered, it has to meet one of these criteria. Now the majority of our conversation today is going to focus on the first 3, an unauthorized transfer, an incorrect transfer, or the omission of a transfer, which generally is a credit that the cardholder claims should be in the account, but isn't. Now, many of the merchant-related disputes aren't going to be covered by Reg E, but as we just discovered, Reg E is still going to expect the bank to assist the cardholder. Some of these situations we'll look at is when a customer doesn't receive goods or services that they've ordered, or they receive the wrong product, or they receive a broken product or poor service. Although our Reg E investigation would lead us to conclude that no errors occurred and that the cardholder did authorize the charge and the correct amount was debited, Visa says we're contractually obligated to provide assistance. The italicized quote on the bottom of page 4 of your materials, taken directly from Visa's operating rules, states, "The resolution of cardholder disputes should be the same, regardless of what type of Visa card is used." A trap that many banks fall into is telling the customer who has one of these merchant disputes that since it's not covered by the reg, there's nothing we can do. Now, as we explore in the scenarios, we're going to see what we can do and what we can't do for our customers, depending on the circumstances. So as we look at the dispute process, the first thing that we're going to do is look at documentation. What can we ask from our cardholder when we're opening a case? First, Reg E 1005.11 does not put much of an obligation on the customer, and I've cited a portion of the reg on the top of page 5. Now in bold, you'll note the customer's obligation for reporting an error. First, the customer must provide enough information so the bank can identify their name and account number. Note that the customer doesn't have to provide all of this information, just enough so that you can locate the information. So if I call up and say, "Hey, I'm Brian Crow, there's fraud on my account. I'm sorry, I don't remember my account number." Now, if you happen to have more than one Brian Crow, which is probably unlikely, there's only about 5 or 6 of us in the country, you might ask me my address or birthday, or something that you think would be able to get you to my bank account. So I've satisfied Part B probably by just telling you my name and then you looking up the account from there. And then Part C, why do I believe an error exists? Well, I didn't do the transaction. Okay, I'm done. That's all you can require under Reg E. You're permitted to ask for additional documentation, but you cannot condition your investigation based on my cooperation. Also, you'll note that nowhere in Reg E does it say you're prohibited from requiring police reports. A lot of people say, "Oh, where in Reg E does it say I can't?" It doesn't. It simply states the limits of what you can require. And that means you're not permitted to require anything beyond Part B and Part C of 1005.11. Now, further down the page, note that with respect to requiring something in writing from your customer, that you're permitted to do, but not as a condition of the investigation, only as a condition of providing provisional credit. So if the customer does not submit their claim in writing, fine, you don't have to provide provisional credit, but you still have to investigate their claim, and that can lead us into conflict with what Visa is going to ask of us. In order to process a chargeback through Visa, the cardholder's word isn't always enough. Now, when it comes to taking down the cardholder's story, Visa does permit issuer certifications of the customer's story, along with the status of their card at the time of the transaction. However, my understanding from speaking with some institutions is that some processors have chosen not to update their procedures to accommodate this change, and so they're still requiring that you obtain a cardholder letter in an attempt to file a chargeback. There's also some situations where we're going to explore where Visa requires the cardholder to contact the merchant first prior to the bank filing a chargeback. Now, when it comes to documentation, Reg E is more consumer-friendly, So in order to stay in compliance, even though Visa requires that you have more documents,